Hello, my name is Kelly Tait. I'm a communication instructor at the University of Nevada, Reno, and I've been working in judicial branch education since 2002 with the National Judicial College, among many others. Today we're going to be talking about verbal communication and how that ties into enhancing procedural fairness. I'd like to start with a quote, and it's one of my favorites. It says, "The single greatest problem in communication is the illusion that it's been accomplished." George Bernard Shaw. And what we're looking for here is something a lot deeper than just the illusion of communication. If we really are trying to enhance procedural fairness, for all the great reasons we've already heard, we need to be going for a deeper level of communication where there's really some effectiveness in there and make sure people really understand what's happening and feel respected. What we're going to be covering today, some of the learning objectives. At the end of this, you'll be able to explore how word choice, including legal jargon, affects those perceptions of procedural fairness. You'll be able to discuss listening techniques and how to be more effective at listening. I also really want you to be able to describe the importance of the 4 key components of procedural fairness: voice, understanding, neutrality, and respect, and how verbal communication ties directly into that and how you can improve that. And then you'll be brainstorming some ideas on your own for how to improve those verbal communication practices you personally have. So by the end of this, hopefully you're getting lots of good ideas on things that you can put into place right away that will help enhance procedural fairness in your courtroom. First, I'd like to talk about what communication is. It's a lot bigger than a lot of people think, a much bigger idea, a much bigger concept. It really is any behavior that people assign meaning to. So that covers a lot. It can be even, not doing something, what you say, what you don't say, what you do, what you don't do. If people assign meaning, it's considered communication. Now, it doesn't always mean they assign the right meaning, the correct meaning, but they are usually interpreting your behavior. So let's say you didn't go to a meeting where you were expected. Are people going to interpret that? Are they going to assign meaning to you not being there? Yeah, maybe not the right reason, but they're going to be making some assumptions and some interpretations based on your behavior or lack of behavior. So communication is a really big concept, and it's been shown to be really closely tied to procedural fairness, ties directly into it, which is why we're doing these trainings. I think there are some special challenges for the court environment in terms of communication. One of those is for you to be able to understand the different needs and capacities of the various court participants. There's a real wide range. And so that's one part of it. The other part is understanding your own communication preferences, your habits, and especially then being able to make adjustments when necessary for those different needs and capacities of those court participants. So within communication, we're talking about verbal communication, obviously. We want to break out what verbal means. And verbal means consisting of words. So we're really talking about oral and written words. We will have another section that talks about nonverbal communication and how you can change the meaning by the way you say it. For now, we're focusing in on the verbal part, the words. And what we need you to remember with verbal communication is that effective verbal communication is not only accurate, obviously we want it to be accurate, we want it to be appropriate, but it also needs to be comprehensible to be effective. And a lot of times in the law field, that gets lost a little bit. The accuracy and the appropriateness takes over, and we forget that comprehensibility is right up there with those elements to make sure that it's effective verbal communication. And this is particularly important with the different types of communication that are happening in the courtroom. So for instance, in criminal courts, some types of verbal communication, obviously we have criminal complaints, witness testimony, evidentiary motions and rulings, plea allocutions, sentencing instructions. There's a whole bunch, obviously, of things happening. This is a field that focuses highly on words, so there's lots happening in court that has to do with verbal communication. In addition, there's all kinds of people who are what we would call court participants who are in the courtroom, in or around the courtroom, and so would be considered participants in the communication. The thing to remember on this is we often break this out as the speaker or writer, if it's written communication obviously, and the listener or the reader. but much of the times these roles are kind of interchanging all the time. So obviously for judges, you are going to be both the speaker and the listener, the writer, and maybe sometimes the reader. So there are times that you will have this switching of roles, but there's a whole bunch of other people in the courtroom that you need to try to think of what their perspectives actually are. That's the key to communication. The key to effective communication is really paying attention to the perspectives that the different people in your audience are bringing to the table, and how that's going to affect what they understand, and then what they do with the information you give them. So we have all kinds of people listening: defendants, witnesses, attorneys, jurors, press, other observers in the courtroom, and many people speaking as well: defendants, witnesses, attorneys, court staff. So there's a wide range of people, and what you need to focus in on with this is the differences in their backgrounds, what different perspectives they bring, the knowledge they already have, right? The knowledge and their experiences, what they have at stake, how much they understand what's happening to start with. All of those things are going to have a massive impact on how effective the communication is, and so you need to keep that in mind in order to make sure that you can reach them in the best way, that it's effective communication, and that it also follows the 4 key components of procedural fairness. Now, I think it's really instructive at this point to focus in on some of the research that's been done on experts and novices. The expert brain is actually is different. We physically change when we learn something. The brain physically changes. And so what happens with experts, they know, their knowledge affects what they're seeing. They're much more able to see what's important, to pick up the patterns and know what's a meaningful pattern. They also need less attention and effort to figure things out in their field of expertise, right? They already have those patterns. They have a way to focus in on what's important right away. One other thing about experts, though, is often, even though they're really good at what they do, they're not necessarily able to communicate it clearly to other people, especially people who aren't coming at it from the same perspective. And they forget how much attention and effort it takes a novice. So as the judge, in the field of law, as the judge with the background you have, even newer judges, you're still much more of an expert than most of the other people in the courtroom. So you have some patterns that you're imposing on it, you're figuring things out and moving very quickly. And often this doesn't work well for the novices in the audience, the people who are not experienced as much at law. So we have a little exercise for you to do here. And just take a moment and see if you can read this sentence to yourself. Now, isn't it amazing you can actually read this? It's amazing. Our brains are something else, that we can make sense of this. And why can we make sense? Because really, if you're fluent in English, we're going to consider you an expert in English. So you have your expert brain making sense of this. You just needed enough of a pattern. And obviously, according to this research from Cambridge University, the pattern you needed here is not so much what order the letters are in, but just that the first and last letter are correct. So the little words are the only ones, little tiny words are the only ones that are actual words, and yet you could still make sense of this using your expert brain that picked up those patterns, and it hardly took any more time than it would have taken to read this if it weren't written in gibberish, because there was enough of a pattern and because you're an expert in English. I've actually tried this in Spanish. Unfortunately, I am not fluent in Spanish, and I was not able to do it. I stumbled, I felt very awkward, and so something that came to me very naturally and almost didn't seem to take effort took a lot of effort when I didn't have the expert brain to make sense of it. So I think that's helpful to think of when you're looking at those different perspectives in the courtroom. One of the other things we want to look at is plain English, is really making this something that's understandable for everybody. Lots of those people in the courtroom we talked about are not law trained. And so we're trying to make sure that everybody in the room understands it. So the big movement, of course, plain English or plain language has been, picking up a lot of momentum. Hopefully your courts have been doing some on it. I have to tell you that virtually every court that I've worked with on this has said that even if they've already implemented many of the plain English practices, always they can get better, always. So that's one of the things about communication. You can be really good at it and still get better, and you wouldn't be here in this position if you weren't pretty good at it already. So we're really trying to just improve on what's already there. So with plain English, obviously trying to ensure grade level appropriateness of the language. So what grade level somebody would have need to have completed in school in order to understand something. With this, it is, there have been quite a few different surveys. It depends on which survey you look at, but the range that they estimate for Americans, the average grade level that Americans understand has been estimated from between 5th and 8th grade, and more of them are on the lower end. More of the studies are showing it on the 5th, 6th grade level, that people would understand it. Clearly, much of the stuff happening in court is well above that. And it's not that you wouldn't use any of the language, any of the legal jargon that's part of the field. It's just if you do need to use it, I mean, maybe minimize it. If you don't have to use it, don't. But then explain, right? Explain those terms. If there are terms that are important to be using, then explain what they mean. Here's the thing. When I've asked many attorneys to define a legal term, what do you think they use to define it? More legal terms, right? So it really takes some work to pull back out of that expert brain that makes those leaps and really think what it's going to be like for somebody who doesn't have that knowledge and that experience to draw on in understanding the language that's taking place in the courtroom. The other thing, there's also courthouse jargon, and I'd say courthouse jargon doesn't necessarily mean it's legalese, but it's things that are used with court staff and attorneys and judges who are used to the system. It might be acronyms, form numbers, things like that that we often use as shortcuts, but that other people who aren't familiar with it wouldn't necessarily understand. Some other practices, good practices for plain English, is really using some of the practices we think of for a little less formal communication, but they work well in terms of making it more clear, clarifying what you're saying. So those would be things like using shorter sentences, using first and second person more than third person, choosing active over passive tense, using more informal connectors, so and, then, now, nice short strong little connectors rather than adding in therefores and things that that might just kind of clutter it up for some people. And I do want to note that obviously with English, anybody who has, there's going to be some issues for almost anybody who's not law trained in the courtroom, but these issues are intensified for participants, court participants who have limited English proficiency. So obviously that's going to make it even more difficult for them. So we're going to do a little exercise on trying to simplify just a bit. There's more that we can do. We'll talk about more tips on how to get to the plain English. There's lots of sites and resources that we'll point you to later. But to start with, let's take a look at a few terms that seem to pop up a lot in legal language. And kind of think about it. Have you ever used these phrases? Things like, have duly noted the contents of. It's one of my favorites. Have duly noted the contents of. What could we replace that with? Have read, right? How much easier, how much simpler. In the event that, easily replaced with if or when, depending, right? Some of the Latin terms, de novo, new, pro se or pro per. I just think it's ironic that we use Latin for the people least likely to understand what it means. So we could say without a lawyer, self-represented, something that makes it clear to people, to everyone. And then you're not losing the people who are experts too, right? They're still with you, but you're also including the other folks who are not experts to start with. So as far as oral communication, and we're going to be looking at this both in terms of oral and written, as far as oral communication, We have some tips for that will help a bit. One of the big ones is to speak clearly and slowly, or at least not too quickly. It is really easy when you've said something many times or you have a lot of time pressure to go racing through what you're saying. And that's when you're going to lose those folks who don't have the expert brains to be able to follow the patterns. So making sure it's clear. It seems so basic. So much of communication really is. Some of it's common sense, but we often need to focus back on it at all different points in our career to make sure that we continue to get better at it and don't fall into the habits that are really easy to fall into that don't help most of the court participants understand what's happening and feel like they have some say in the process, some voice in the process. So obviously we'd be looking at having you explain legal terms. I think you should practice your explanations though. You should practice it with somebody who isn't law trained, right? So see if you're getting an explanation that makes sense to somebody, and you know plenty of people, right, who are not in the legal field, that you could try out these terms and see if you have a nice, clean, clear way to say them. And then I know lots of judges will have, those written down as almost a cheat sheet that you can go to so that it's easy for you to grab the clear terminology that will reach everybody in the room. Obviously, we're looking for explanations of things like, what do they need to do to be in compliance? What are the consequences of non-compliance? If you put these into words in a clear way, you're much more likely to get compliance. It's a lot easier to follow the rules if you know what they are. And I can't tell you how many times I've been in many courtrooms, and I've seen times where it was not clear what a defendant had to do to comply. And even when they asked questions, it often wouldn't seem to get fully answered. So even if somebody wants to comply, it's making it more difficult to not make it a clear, clean explanation of what needs to be done and what happens if it doesn't get done. I also think it's really good, if you can, to reinforce oral communication with another channel of communication. So with something written, for instance, a written order, some kind of written reminder. This means there are some pretty big differences between oral and written communication. Oral communication does have an immediacy that a lot of written communication does not. So there's an immediacy, and if somebody's being a responsive communicator, then they can clarify things when it's clear, when somebody hasn't understood it, add to it, whatever it is. You can do that when it's oral communication. With written communication, you do get some benefits. You don't get the same immediacy, but people would have the chance to be able to look back over it, to reread it, to look up words, for instance, if they didn't understand it. So there would be things like that would allow a person to maybe grasp it in a different way, which is why we're saying it's a nice thing to do, to try to reinforce your oral communication with something written whenever possible. Okay, some more tips on effective oral communication. I think a huge one, I talk about communication tools a lot, but when I talk about paraphrasing, I talk about a power tool. This is, it's really effective to use paraphrasing, and to use it both directions. For you to put things into your own words to show that you understand or to clarify something, but also to ask court participants to paraphrase, so to put something in their own words. And it's the best way to find out if somebody understands something, you or other people, is to have them put it in their own words. So that's one of our big tips to do. Build that in. Obviously, you can't do it all the time. You'll pick the places that are most important for understanding and use it there. Also, when possible, you'd want to organize your message, your oral message, in a way that makes sense to the listeners, to the participants, not just to you. Now, I know sometimes things have to go in a certain order, and it has meaning within the legal field, but maybe not to those who are not legally trained. So if you have to follow another organizational pattern, then at least give an overview of how it's organized, how a process is organized. So kind of a mental map of what's ahead. It really helps listeners to have that sense of how things are organized in advance, and then as they hear it, they can put it into place. So ideally, you're choosing an organizational pattern that makes sense to the listeners. At the very least, you're giving an overview of that organization. And I think you should do that all the time, that little bit of an overview that will help people make sense. And so we have a little exercise that comes along with that idea of the organization having a big impact on how clear the communication is. So what I'm going to do, there'll be a slide coming up that will be up for about 5 seconds. And I want you to just look at the slide and try to remember as many of the words on it as possible. Don't write them down, you won't have time. So look at the slide for 5 seconds and see afterwards how many of these you can remember. Ready, go. Okay. Now take a moment and go ahead and jot some of these down. How many of the words do you remember that were on that screen? Quickly jot a few down. I know everybody got some. See how many you can remember. All right, we're going to do this exercise again a little differently. These are the same words, just in a different organizational pattern. All right, same words in a different organizational pattern, the same task. You have 5 seconds and see how many of the words you can remember after the 5 seconds. Ready, go. All right. Now, if you're going to write those down, I bet you're going to get north, south, east, west, man, woman, boy, girl, all the directions, all the colors, the people, and then maybe you could spend a little more time on the flowers because there's not always 4 flowers that come together. The format information is put in can make it much easier to understand that content, even when the content is pretty simple, like what we just saw. So I put that in an organizational pattern that made sense to the participants, to the listeners, to the readers. And it's much easier to grasp when there's a pattern that we can make sense of. If you don't already have a pattern, right, if it doesn't make just logical sense to the average citizen, then you would also just make the organization clearer. And you can do this by using verbal cues too. So for instance, here's the slide again, and I could have it written or also say there are 4 categories with 4 items each. And so I've given that kind of organizer, that mental map of how things are organized. 4 categories, 4 items each. That really doesn't take much time to say that brief little organization. It pays off in spades in how much people can remember then down the line. And giving them something to hold on to, 4 categories, 4 items, and putting it in a pattern that makes at least some sense to them really helps with the comprehension with oral communication. So of course, as we're talking about verbal communication, we've talked about oral communication, and I want to focus in now more on written communication. There are lots of things written in this field as well, in the legal field. Really, our biggest goal is write clearly, direct, and to the point. And there are often times where it does not seem like legal writing fits that criteria. I think it takes a little extra work sometimes. Again, we're looking for explanation of the legal terms that need to be used that are important for people to understand. In addition, written communication gives you the advantage of being able to list steps that then people can go back to and make sure, say if you have a list of the steps necessary for someone to comply with an order, then they have that list that they're taking with them. And it does give it kind of power to have it in writing, and it makes it more likely they will comply as well. In addition, the written consequences, explanation of consequences for non-compliance, all of these things can be done in writing as well. There are some tools that you can use in terms of looking for the readability level. So the readability measure that would be saying that grade level equivalent, whatever your writing is, what level your writing is that would be understood by people at a certain grade level. There are quite a few tools that you can use to help you evaluate that. So that's one way to simplify your writing at least a little bit. Again, having other people read it who are not legally trained to see how it comes across to them and get feedback on it. The best way to get better at communication is to get fairly quick feedback and then to try to act on it. In addition, you can give in writing additional information, contact information for people, additional sources of information for them to go to. So there are quite a few things you can do with your written communication. I'd like to focus in on some signage issues in particular as we talk about written communication. Obviously, there's a lot of different things in writing. I think it's worth looking at everything again. I know you're busy. I still think you should Take a look at the website. What is said there? What's written there? How does it come across? Is it easy to find? Is it easy to understand? Look at the forms that are out there and walk through your courthouse and look at the signs. Try to look at it with new eyes. Walk through the public entrance and look at things with new eyes. Would you know where to go? Would you feel like you were welcome enough that you really could have a meaningful chance to participate in the court process? Things like that. So let's look at some signs. A lot of the signs we're going to be showing pictures of are from the Milwaukee court where we did our pilot program. In the meantime, they have made some changes, so we did focus in on the signage and things have been changed. It's a beautiful, beautiful old courthouse, and they had many things they were doing well, but they still had a lot they could improve on. So for instance, this sign, we have a sign that gives information, but really is still not communicating effectively. In this sign, you have lists of judges, and so they're not really organized in a way that makes sense. They're not alphabetical. They're not by courtroom. They're not by floor. They're just in, so we know that they're all judges, but we really don't have any organizational pattern to it because they change things at different times, and so they didn't really follow a pattern. There are some places on there where it has the particular types of court, but they also have them in different places across the sign, where one is spread to the right and another one's to the left, so it's hard to tell what goes with what. It's often hard even to line up what is the number, the room number that goes with this particular title. It's really hard to tell what's happening here. So even though you have a sign with what looks like a lot of information, doesn't mean it's communicated clearly. This sign we found was one of the clearest and most eye-catching signs in the entire courthouse. Sadly, it had very little to do with court. It had to do with food. We knew right where to go to get it, and a nice big sign of nice big words, arrows. We had pictures to kind of add to the words, which is a nice way to do it. But unfortunately, this isn't what we'd want to be focusing on the most in the courthouse. We'd rather have some really good, clear, strong signs for some of the other stuff related to the court. We looked at a lot of the different signs on doors of the different judges leading into their courtrooms, and they had a lot of choice. Each individual judge had maybe a different way of doing it, and their staff, of course. But take a look at this sign. I thought this may be my favorite sign there. We are looking for signs that are informational. We also want them respectful and welcoming, ideally. There's no reason not to say, remember the 4 different factors of procedural fairness, that people feel like they have a voice in it. It has to be welcoming enough that they are going to feel like they have a meaningful chance to be heard, that they are treated with respect, right? That there's a neutral person in power trying to do well. So this is the kind of sign that might get that across to start with. That they understand what's happening too. That's the 4th one. So here it is, welcome, right? Welcome to the courtroom. And it says, this is a public courtroom. This is your courtroom. Come on in. Please walk in. I'm not saying you have to have a sign just like this. This is maybe one end of the spectrum. But it is on the spectrum. It's on the scale. You can choose to do things like this. You should look at what people are going to feel when they walk up and see what's on the door into this room they're stepping, where all kinds of stuff that has to do with their lives or people that they know is going to happen. And it's a very intimidating environment, very intimidating. So if you can do something to make it a little less, we want people to follow the rules, obviously, and they're not going to know them. I understand we should have some signs out there about the rules, but let's look at different ways to do that, different ways of using verbal communication, and see if you think that these signs does it convey what the court participants need to know to start with, and is the tone respectful? And can't it do both at the same time? Give information and be respectful too. Information so that there's that understanding, right? But also keeping respect in there, because that ties directly into perceptions of procedural fairness. So you have the no, 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 no on the one side, right? Is this what you want? Is this clear enough? Is this going to not just tell the rules, but also set the tone that you want? And your choice of words has a pretty big impact. So take a look at it, see what's out there, see what your signs say, and evaluate them. We have some examples of some sample signage to show you different ways that it can be done. Improved signage often uses images with the words, much stronger. If you're getting it through more than one channel, right, through the words and through images, it has a bigger impact. You reach a wider audience, so even if there's some issues with the language, you're more likely to reach people with those images too. So you're getting the meaning across, but also being very respectful. Respectful language when possible. So right at the bottom of that sign, it tells you what you can and can't do, tells you no food and drink in the courtroom, but here's where you can go to get it, right? And then thanks them for their cooperation. So you're getting, the rules are in there, they're clearly in there, but it also has a respectful tone. It is possible to do both. We have another one. This sign could be, we've seen the sign sometimes outside and inside where people are waiting. So in the courtroom, you have the rules again and things that people should do so that if they walk by the first one, they still have a chance to see what those rules are and get the information a little further down the line. So a sign like this could reinforce court procedures. You can answer those frequently asked questions right there. There are some questions that always come up. Just give them the answer. Don't wait for them to ask. So again, we have a welcome there. We have pretty clear, here's what you need to do. If this, please do that. And so that you're going to have a lot higher level of understanding of the procedures based on this sign and also that welcoming, respectful tone. With that, we're going to kind of focus in on listening in particular. It's kind of tied into everything we've been talking about so far, but there's some specific tips about listening well, and I like this quote from John Marshall, Chief Justice of the U.S. from 1801 to 1835. To listen well is as powerful a means of communication and influence as to talk well. We often think of listening as kind of a passive thing. To do it well, you need to think of it as something more active and to understand how powerful it is to do well. We're going to look at both how to kind of help you as a listener. All of us can get better. Like I said, you could be really good and still get better. And then also some tips on how to help other people listen better, the other participants in the courtroom. To start off with, listening, we talked about different communication skills. Listening is the most used and yet the least taught communication skill. We do it a lot, but that doesn't necessarily mean we're very good at it. So they've done some studies, and these studies, it does depend how much information was given, how long a period of time somebody had to listen, how far down the line they were asked about what they remembered. But they did find that for most people, they listen at about 25% efficiency. And this is shortly after they've heard something. To be able to have understood and remembered what was said, they remember about 25%. And there's ways to bump that up, adding the images, adding repetition, chunking it so you don't have too much information at once. Things like that will help. But in general, if we say an average 25% efficiency, right, think of how much is getting lost. In the courtroom, this very intense environment for very many people with a lot of emotions going, those emotions can create an internal noise that almost gets in the way more. So they might be at a lower efficiency. And let's say you are really good at listening. You probably are. It's a big part of your job. But let's say you're twice as good as the average person. Where does that leave you, right? It's still at 50%. So we can all get better, even if we're really good. And clearly, we would like to have it better than 25% efficiency so that we're using our time effectively. With that, we're going to kind of focus in on listening in particular. It's kind of tied into everything we've been talking about so far, but there's some specific tips about listening well, and I like this quote from John Marshall, Chief Justice of the U.S. from 1801 to 1835. To listen well is as powerful a means of communication and influence as to talk well. We often think of listening as kind of a passive thing. To do it well, you need to think of it as something more active and to understand how powerful it is to do well. We're going to look at both how to kind of help you as a listener. All of us can get better. Like I said, you could be really good and still get better. And then also some tips on how to help other people listen better, the other participants in the courtroom. To start off with, listening, we talked about different communication skills. Listening is the most used and yet the least taught communication skill. We do it a lot, but that doesn't necessarily mean we're very good at it. So they've done some studies, and these studies, it does depend how much information was given, how long a period of time somebody had to listen, how far down the line they were asked about what they remembered. But they did find that for most people, they listen at about 25% efficiency. And this is shortly after they've heard something. To be able to have understood and remembered what was said, they remember about 25%. And there's ways to bump that up, adding the images, adding repetition, chunking it so you don't have too much information at once. Things like that will help. But in general, if we say an average 25% efficiency, right, think of how much is getting lost. In the courtroom, this very intense environment for very many people with a lot of emotions going, those emotions can create an internal noise that almost gets in the way more. So they might be at a lower efficiency. And let's say you are really good at listening. You probably are. It's a big part of your job. But let's say you're twice as good as the average person. Where does that leave you, right? It's still at 50%. So we can all get better, even if we're really good. And clearly, we would like to have it better than 25% efficiency so that we're using our time effectively. Some of the tips to use when you're the listener, when you're the one who's trying to be listening better, is to kind of start with some preparation, to really start with saying, all right, what do I need to do in order to be ready to listen? And some of this is even just the right frame of mind, understanding how important it is to focus, how easy it is to get distracted. So that preparation of the right frame of mind and being physically ready to listen. What do you usually do? What does somebody look like? What are they doing when they're listening? What do they say? What verbal communication do they do that shows that they're listening? So start looking at those things and then do them. Physically get ready to listen. And that might mean sitting up, sitting forward a little bit, leaning forward, some eye contact, right? Those are the signs that we see that somebody's listening. And remember that the voice, meaningful right to be heard, is one of those four basic elements, four crucial elements of procedural fairness. So if somebody sees that you're listening, they're more likely to feel like they had a voice in the process. So you'll look at those things, be ready. You'll be working to see things from others' perspectives. I think it takes some work to do that, to remember how different other people's experiences and knowledge and emotions might be about what's happening. It also takes some work to try to withhold judgment. This one, I know it's part of your job, right? Don't prejudge, right? Don't leap to conclusions. But it's also part of how we're built, how the human brain is built to make these really quick leaps, built to move really fast. And so you actually have to consciously hold back on your judgment, pull it back so that you can hear things without it already being colored by one of those conclusions that you might jump to. In addition, it's really good if you can build in two-way communication when you're the listener, where you do say something, build in a chance. If you know you're going to be speaking up, it's going to make you listen in a different way. So if you have a chance to paraphrase what somebody said, ask a question, do something verbally to show that you're listening as well, and to open it up so it's not just communication coming one way. More effective communication is two-way communication, even if it's not that way all the time, to build in some opportunity for that. In addition, I think kind of developing techniques to make sure you stay on track or to get back on track. One of these would be, one of the big ones I think I've heard from a lot of judges, is evaluating your note-taking and kind of what system you use, and does it work well for you, so that I have many, many judges who say that's what they use to stay on track. That's how they make sure they're listening well, is the way they organize their notes. And it might be columns, they might have different techniques in what they do. Evaluate yours. Does it help you? Does it help you pay attention? Does it help you down the line when you have to refer back to them? These are things that you can do to get a little bit better at it as a listener. And finally, really building self-awareness and skills at this. You can get better. A lot of it is paying attention to it, right? The attention that you put on it yourself, understanding what you're good at and maybe what you can work on as well. The next step of this, of course, you as a listener, but also helping others listen better. And actually, one of the big lessons of listening research is that the quickest way to help others listen better is really in some things that you, as the person in charge of the communication, the person really running it, the choices, communication choices you make will have a huge influence on how others listen and how well they listen, what they understand, and what they remember. So some of the things that we've talked about already in terms of having the mental map ahead of time, that will help people listen better, right? Some of those things that you just build in automatically do them. I think reminding people what's in it for them, why they should listen, right? Why they should listen, that there's some common ground, that we have a goal here today, in order to make the fairest decision I can, right? That's going to focus them in on things. In addition, I think it's good to make it participatory. This is kind of another way of saying two-way communication. So not just that they are sitting there listening, but also that they're going to have to respond. And obviously this ties into what we talked about with paraphrasing, making sure that they get a chance to speak up. But it's most effective if you both let them know there are going to be these chances to speak up and also let them know when it's going to be. That you will have a chance to ask questions. First I'm going to do this, then I'll open it up to make sure you understand. If you're going to have them paraphrase something, letting them know. You don't want it necessarily to seem like a pop quiz, so you've got to be a little careful how you say it. But if you say something like, it's really important that you understand this, so I'm going to explain it to you, and then I'm going to have you put it into your own words so that we make sure that we're clear on this. You can say it in a way that isn't condescending, that still makes it clear why it's a good thing for them too. And letting them know. This is one of those things that with my college students, one of the ways I can always get them to tune in just a little bit more is to say something like, this is likely to be on the exam, right? And all of a sudden they're raising their hands and asking questions and taking notes because they know they're going to use the information. So if people know they're likely to have to use the information down the line, but ideally even sooner, right, that they're going to have to use it, they're going to listen in a different way. They're going to tune in a different way, and they're going to try to make sure they understand it as well. So it's one of the things you can do to help them listen a little better. I think it's worthwhile trying to create an appropriate environment for listening. A lot of things happening, different courtrooms obviously run differently, even different days in different courtrooms might have a different amount of sound going on, a different amount of activity going on. If possible, of course, you'd be minimizing background noise. There may be times you need to amplify sound, the important stuff, and tamp down the other stuff. But look at the whole environment. And on this, I do actually recommend kind of going and sitting in different parts of your courtroom. Hopefully you've done it at some point. Do it again and just go see what it feels like to be sitting there and how engaged you might feel or not. How likely that you'll be able to really see what you need to see. And then you can keep that in mind, that idea of the perspective of everyone in the courtroom. That will help you keep that perspective for you to picture what it was like sitting in these different places. Another thing I think you should do is reinforce important information. This is something that you could do things like have the multiple channels, something written and have images. Use repetition. It's one of the ways, the main ways that we learn is through repetition. So if something's important, you build it in, make sure they hear it more than once, get it more than one way. Also things like what we would call flagging, saying things like, it's especially important that you do this. It's really important that you remember this. You're flagging them or telling them, the 3 things you need to do, 1, 2, 3. Something that gives them a way to remember that it's important and that there's more than one item. Now we really want to bring this all together, all the different things we've talked about in relationship to verbal communication, and really apply it to those 4 key components of perceptions of procedural fairness: voice, understanding, neutrality, and respect. So we want to align. I want to use this section to kind of align what we've been talking about, maybe some more ideas along those lines with those 4 key components. So I'd like you now to take a couple minutes and really think about it and write some things down of what are some of the specific things that we've talked about or some other ones you've thought of that would come under these areas of someone feeling like they had a voice in the process, they had a chance to be heard, that they understood what was happening at least enough, that the decision makers, the people in power, were neutral, that they were trying to be fair, and that they were treated with respect. So take a moment and write down some ideas. All right, so let's look at these one at a time, those 4 key components, and I'll tell you some of the things we've come up with. Hopefully you've added to them as well. In the first one, in having a voice in the process, some of the things that we thought about were really telling defendants or other court participants when there will be an opportunity to speak up and ask questions, letting them know that ahead of time so they know they will have a voice in the process. Explaining the parameters of the information you're going to need from them. We can't just open it up and say you're going to have an opportunity to tell your story indefinitely, obviously, so we need to have some parameters there. If you let them know up front what you need from them and what you'll need to, maybe you might need to bring them back to that if they get off topic, then they still feel like they've had a voice even if it's not unlimited. In addition, paraphrasing fits beautifully under this particular component, right? To show your understanding. They know they've been heard. If you put into your own words what you heard, it shows you're listening. And so that adds to that feeling that they had a voice. I think it's also good for the judge to explain that you will consider all of the evidence, including the defendant's testimony, if that's applicable, before reaching your decision, because sometimes where people have an issue is thinking they're not going to get the chance. Somebody else is saying something that they don't agree with. They want to counter it right then. So understanding that you are still holding back, you're not going to prejudge, you will hear everything, makes them know that their voice will be heard as well. The second key component we're going to focus in on is understanding. Did they understand what was happening enough for it to be meaningful? In this, I think it's really good to be doing things like checking for the signage, checking the clarity, the placement, the amount of signage, what is being communicated through those words. I also think you should be checking all of the written resources, as I mentioned before, what's online, the letters that have been sent to them, the forms that are out there, what's being said to them already, and is there a way to make sure that that language, the words that are used there are as clear as possible. I think it's also a good idea to make sure that that initial dialogue you have with the defendant, or when you start court, you can do some assessing of people's English skills, English language abilities, for instance, making sure you get some sense of how to communicate effectively and if anything else needs to be done to make sure that they do understand based on their language abilities. Again, we're going to tie right into, you're going to hear a repetition on this because I want you to remember it. Use simple, non-jargon, non-legalese words whenever possible. When you do use legal terms, and it's important for them to understand it, explain them, explain the terms, and of course, check those explanations. Make sure they're clear, not just that you think they are, but that you've checked them with people who don't have the same background that you do to see if they get it too. Some other things for understanding. This ties into paraphrasing again, this time, of course, asking defendants to repeat back their understanding in their own words of what they heard. And so this might include things like no contact orders, rights they're waiving by pleading guilty, sentencing terms, things like that. Make sure they get it. If it's important to make sure they get it, that they understand it, and they will also have the feeling that you want them to understand it if you ask in the right way. If you let them know why you're asking this and why they need to put it in their own words. You can also let defendants know they can have a short break to ask their lawyer questions if there is a lack of understanding, right? That there are other things they can do to try to make sure that they can add to the understanding so that this component is fulfilled as much as possible. The third key component, neutrality, so that they thought the people in power, the decision makers, were neutral, were trying to be fair, right? Had good intentions to be fair. On this, in using verbal communication, state up front that fairness is a goal. That's something you can do right up front in order to be as fair as possible, right? So state it up front so that it's out there. It's good for them to hear it. It's actually really good for you to remind yourself. By you saying it, it's also reminding you that it's one of the goals as well. Transparency is another thing, really important. Be transparent about the decision-making processes, right? What led to this? What happened and why? Transparency ties directly into neutrality. If people feel like they can see what happened, that they understand it, that adds to neutrality as well. In addition on this, there are going to be some parameters on decisions that you make, some constraints perhaps. Be transparent about those as well. There's only so much you can do within the guidelines here, right? Let them know that up front, what those are and why that happened. Transparency is huge. I also think it's really important to pay attention to how you address different people in the courtroom. For instance, defense attorneys, prosecutors, even self-represented litigants. Everyone should be treated with equal levels of respect. And that's the level of language you're using, the form of address that you use, also how familiar you seem with somebody. If you know someone well, that often comes through in your choice of words. So you want to be very careful to make sure you're not tipping the balance and making it seem like you're not neutral because you do know some of the people involved better than others. And the fourth component, respect. Did they feel they were treated with respect? This starts, of course, from the very beginning. I think we talked about signage and things like that in addition, what language is used there, but also introducing yourself, that beginning of court, what happens when you come in? Introduce yourself, introduce the format of the court session, right? I think it's respectful to tell people how things are working, to give them that overview. It's also good to thank all court participants if they had on-time appearance, if they're being cooperative, they're trying to participate in this process productively. It's worth thanking them. Greeting each defendant by name. There's power in names. Trying to get the names right, having some effort in trying to get the name right, huge. And ideally, you're tying this in with some of the nonverbal communication we'll talk about a little bit later, such as eye contact, such as paying attention to your tone of voice when you say it, when you're greeting them by name, each individual. It's also, I've had many judges who've talked about, if they have heavy dockets and they're seeing numerous people, one after another, and they hardly have time to look up, that it's very easy to forget you're dealing with individuals. And it feels like that on the other end if you're not being dealt, that you're not being treated as an individual. Using someone's name and looking at them as a person is one of the ways that not only will they feel that they are being treated with respect, but also you'll remember that they're an individual and kind of reminds you to do what you would want to do anyhow, but what's really easy to lose when there's so many people moving through the courtroom. Some other things with respect, when it's appropriate, if there's been things happening, some kind of treatment that maybe would appear disrespectful, say court started late, that there are very long security lines, things like that, I think it's worth saying something about that, apologizing for it, letting them know maybe what happened, at least acknowledging it, and rather than just acting as if nothing happened. Much more respectful to acknowledge it. Another thing you can do that I think is very respectful, you don't want them to interrupt you, but you may have to interrupt them if they know up front, if that's kind of one of the ground rules, that you might need to interrupt in order to keep things on track and to use the time as efficiently as possible. If they're told that up front, then if you do have to interrupt them and turn them a little different direction, it's much easier to do in a respectful way because you told them up front you might have to do it. Well, remember when I'm sorry to interrupt, but remember when I said there's certain kinds of information I need from you and a limited amount of time. What I need from you now is, so you can kind of redirect them in the way that you want, and it's very respectful, feels much more respectful than just being interrupted if you didn't know that might happen. And really all of these things, all of these 4 key components are so closely tied to communication, and obviously in this case verbal communication, to the words we're using orally and in writing. Hugely important. And when we are trying to have the impact that we are, when we know that when people perceive the process as fair, they're more likely to comply, they're more likely to speak well of the courts. It raises people's opinions of the courts in general, in addition to their individual treatment in the cases. It's huge. And procedural fairness requires way more than the illusion of communication. We're trying to get a lot deeper with that, and that's why we're focusing in on verbal communication.